strict adherence to ethical principles in the legal profession and society at large is facing serious challenges. Today, more than ever, there's an urgent need to recommit ourselves to the fundamental values of ethics, discipline, and professional responsibility.
Welcome back. Many thanks for joining us. That is the Chief Justice of Nigeria, Justice Kekere-Ekun. The need to sanitize the Nigerian judiciary, the Nigerian legal space, is not only the first time we've been hearing the call. Since time immemorial, such calls have been coming from prominent lawyers, been coming from prominent political analysts and pundits as well. But this call at this moment is quite loud, and we want to give it a talk. Of course, in the frame of policy discourse, right here on the front burners, where we burn things to the ground. That means, making sense of it. And we're having a lawyer join us on this conversation, Rebuilding Trust in Nigeria's Justice System. His name is Deji Ajare. He's a lawyer and executive director of Sterling Law Center. Good morning to you and welcome to the front burners, Deji. Are you there? Yes. Oh, Deji, if you can hear me, kindly please unmute so we can hear you over here.
Having me.
Thank you very much for joining us this morning. You heard the Chief Justice of Nigeria, the Chief Judge of Nigeria, Justice Kekere-Ekun, the speech we just played as a prelude before commencing this conversation with you. Could you please briefly tell us the implication of that speech, the need for that speech, and how you see it come together in the conversation of building trust in Nigeria's justice system?
Yes, thank you again for having me. And of course, I listened to the Chief Justice of Nigeria, and the concerns she raised are quite valid. They are concerns that have been, quite a number of persons who are interested in the developments in the justice system have been raising for some years now. The issue of declining ethical standards amongst lawyers in Nigeria is a concerning one, and the fact that it is being raised at this point by the Chief Justice of Nigeria makes it quite even pertinent. You see, because ethical integrity it's a core, it's the backbone of the legal profession. And when it is missing or when it is declining, then it is capable of negatively impacting perception of the public about the justice system generally. And so one cannot but agree with the CJN, as she has rightly pointed out, that when lawyers who are custodians of the rule of law fail to uphold ethical standards, the implications for justice delivery and societal trust are very dire. And of course, one would also agree with her that the body of benchers occupies a very strategic and vital position within the profession. It is positioned, it is the body that is properly positioned to spearhead the restoration and sustenance of ethical discipline amongst lawyers. So we agree with the assertion that the body of benchers needs to proactively and transparently use its disciplinary mechanisms to restore discipline and reinforce standards. But you see, the body of benchers in doing this must first engage in a process of self-introspection. The body of benchers itself, made up strictly of persons who are lawyers first, and who probably are also now judicial officers. The point being that the body of benchers itself has been indicted of failing in the past to uphold ethical standards. It has been indicted in the past of failing to adhere strictly to these ethical standards that that has been part of the legal profession from time immemorial. And a case in point in recent times was, I mean, some years ago, when the chairman of the body of benchers refused to step down when a complaint was sent to the body of benchers for the investigation of a lawyer working in the office of the body of benchers, particularly when the unethical practice that the lawyer was accused of, I mean, ropes even the chairman of the body of benchers in, because the allegations were weighty. It seemed to imply that the chairman of the body of benchers was throwing his weight around to get judgments. And apart from that, it also involved a situation where somebody was trying to lure the client of another lawyer, a very unethical practice. See, but then the chairman of the body of benchers refused to recuse himself and sat on that panel that was investigating that lady. You cannot tell me that the chairman of the body of benchers does not know that the fulcrum of the justice system is not only that justice is done, but that justice is seen manifestly to have been done. So the issue of perception is key. So irrespective of what the outcome was, the fact that the chairman of the body of benchers refused to step down at that time was a very big indictment, not only on the body of benchers, but the entire legal profession and the entire justice system.
Oh,
Let's look at this since we're talking about the justice system. Um, for quite a while, I think that has reduced maybe during this current dispensation. But we saw an era where it was as if politicians were shopping for ex parte orders. So one court gives an ex parte order, before you know it, another court is giving another one regarding that same case. Now, what part of the legal system do we hold responsible for this, and how do we address that issue? Because it's one of the issues that has made kind of ridiculed the justice system, where it's as if, oh, it depends on where you go to. If you get an ex parte order, I can also get another that conflicts that.
You see, it is impracticable to sit down and dissect the justice system or the legal system into bits and put the blame before one or the other. But I think it's a whole system. And when the whole system, when anything is wrong in the system, it is wrong. And that's just it. You see, both from the judicial part, the bar, the bench part, and the bar parts, the lawyers parts, there are problems, there are issues. And I say first, while of course we have spoken so much about the judiciary itself, for the lawyers, this is the point that I make. Politicians do not know where to go to get ex parte orders. They do not know where to go to get injunctions. So who gets them those injunctions? It is the lawyers. And so we must put the blame squarely on the main actors in that justice system, the lawyers, the judicial officers themselves. Because politicians will be politicians. Politicians will take advantage of any loophole that's available. But who points the loophole to them? Who shows them the road? If bribe is going to be taken, no politician will approach a judge directly to go and offer them bribes. It will be through the lawyers. It will be through the lawyers. So we must tell ourselves the truth. The point is that judges, who first, of course, are lawyers before they become judges, and practicing lawyers themselves, are at the center of all of these issues. And if they fail or refuse to give this, to point the politicians towards these directions, you can be sure that the politicians will not seek these orders. And it is quite interesting that what you even have these days is a situation where those politicians, I mean, the clients themselves, when they approach a lawyer and a lawyer tends to want to, avoid engaging in such unethical practices, they say he's not a smart lawyer. They say he's not a smart lawyer. So putting it is now apparent and now obvious that for you to be successful in legal practice, you need to engage in these unethical practices. It's a major indictment on the profession. It's a major indictment on the justice system. But then again, the question I will now ask: when the head is bad, Can you expect anything of the fish? Now, the point is that at the end of the day, if there must be reforms, if we must get things right, then it must start from the very top. So if the CJN is making this call, which I totally agree with, then the CJN must start from her desk. Now, at the judiciary, the NJC, the JSCs, as they are, what are they doing? What steps do they take to ensure that complaints about erring judicial officers are properly handled? What steps are they taking to ensure that unethical practices among judges too are properly addressed? Just a few days ago, there was a story about a judge of the Federal High Court who was, I mean, of the Court of Appeal, who was seen at a public function tended by the Minister of FCT, and there were, there were complaints that, oh, did he escort him or did they meet there? Whichever way that turned out to be, the fact is that before now, in former times, judges who are enjoined to avoid such public functions would usually very scarcely have the need to come out to explain themselves, to explain why they were there or why that person was there. The reason is because they maintained the ethical standards. But today, because you have judges attending Owambe parties, you have judges attending every function, you have judges attending functions where they are given awards, and then they meddle in political discourse. At the end of the day, like we said, the public perceives these things as capable of influencing outcomes of judicial decisions. And as such, irrespective of what the genuine intentions are, once the public perceives that, look, there are chances that, look, these politicians might be able to influence outcome of decisions, I am making this call again to the CJN that she needs to sit back and clean her own house first, because she heads the judiciary. She is also the head of the NJC, and which is responsible for discipline of judges. As such, they must ensure that they must go back to these standards. When that is done, 50% of the problem is solved. Then you can now face the lawyers themselves. And of course, the body of benchers, the legal practitioners disciplinary committee, will now be asked to ensure that it also disciplines its own erring officers. But as it is, as long as you don't start from the top, you're not likely to achieve any results.
Thank you, Deji, for those very brilliant submissions. I want to ask, are you not thinking that somehow we're over-stressing some of these conversations around ethics in the judiciary? Because some of the issues that we actually talk about, some of them are not, they are not really fact-based or evidence-based, as it were. That the problem really could be the fact that we are not good winners and good losers as a country. And anytime a case does not favor you, is the church has been bribed or something has gone under the carpet. Don't you think that the way we receive victory is also part of the real problem that is affecting the image of the judiciary?
The discussion as to whether Nigerians are good losers, good winners, that would be a totally different discussion. But the question I would want you to look at is this. Did we always have it like this? Was it always like this, that people would always complain about the judicial system as being biased? I don't think it was always like this. I do not think so. So something changed somewhere. And it is that thing that changed that we should be concerned about. Now, I have said it here, and I'm going to repeat it again. The thing about justice, at the core of it, is not only that justice is done. Justice must be done, yes, but it is not just enough that justice is done. But it is important that the perception that justice is done is maintained. And one very fundamental way for that to happen is that judges and judicial officers must avoid interactions that are likely to create apprehensions in the minds of the public that there is a chance that decisions of the courts could be influenced. And so, while it is possible, like I said, that sometimes outcomes may not necessarily be palatable, and so the people may, without any the further evidence, just the judge has been corrupted, has been influenced, has been bribed. What is important is what led to that perception. And I tell you that that is a fundamental part of our justice system. So if we are missing it, then we need to retrace our steps. And that is the point that is being made. Now, all over the world, this form of justice system, this formal justice system that we have, is the winner takes all. Naturally, parties are always going to leave. One party is always going to leave unhappy, certainly. And it is the same all over the world where you have formal justice systems like this. But everywhere, naturally, you're going to have people who complain, and so people would sometimes put the blame on their lawyers, or sometimes put the blame on inefficiency, but at least they do not put the blame on, they do not suspect that there have been influences on the judges that led to the outcome that they are seeing. So it is for us to get back and ask ourselves 30, 40, 50 years ago, how were judges living their lives? How were judges maintaining that form of ethical standard that prevented them from being embroiled in the politics, in the politics, and or being associated with politicians that will eventually lead to a decline in the trust for the justice system?
Thank you very much, Barrister Deji, if I can call you that. Rebuilding trust in Nigerian justice system. First of all, I would like to know the role that the NJC plays in the gamut of the Nigerian justice system, the Nigerian Bar Association, NBA, the role that it plays in the whole system. Also, the body of benches that you are talking about, so that we can understand all this, what I call it, fragmentations, and also the Nigerian Legal Practitioners Disciplinary Committee. I also want to know the role that it plays. Now, the reason why I'm asking is this. On this table, we discuss business, economy, and development issues. And the conversation we're having you today seems to delve towards development, but it does have a business and economic impact, because sometimes conversations or deals and transactions on business and economy will end up in the court. And if there is no justice system that is in place to carry out justice, to let the pendulum justice swing the right way, then people will begin to lose trust in that system. And they need to build that system, to build trust into that system. It's very, very key, because it has an economic and business impact for the growth and development of our country. Not too long, a senator, a politician in the National Assembly spoke about how he spoke with with his wife, who is a prominent lawyer in the country, and how he had influenced his wife to sway the cause of justice for some of his friends in the National Assembly. And legal practitioners, everyone came out to cry foul, and how the whole system should respond to bring sanity into it. And we didn't see anything. Now, what is the damage this would have done to Nigerian business, economy, and development strides? And how can we correct that anomaly?
Yes, you see, I had mentioned earlier, the NJC is the highest body for the regulation of for the discipline of judicial officers, and until it wakes up to that responsibility and do it in a proper manner, we're going to definitely have challenges. And again, I think we should even start from the very beginning, from the recruitment of judges for the higher courts. That process needs to be strengthened better than it currently is. It should be more transparent. I mean, the conditions and the process entirely should be very open. People should be able to see, oh, why this person is being, maybe appointed as Court of Appeal judge from the High Court, why this person is being elevated from the Court of Appeal to the Supreme Court. Or people should be able to see from the quality of judicial decisions. People should be able to see from the quality of their lifestyle. People should be able to see that, oh, persons who have had um, allegations of misconduct against them punished by not being promoted. But that is not what we currently have. There's a lot of hush-hush around the appointment of judicial officers, and despite all of the outcry the NJC does, nothing about it. In fact, it appears to actually be getting worse. And that's just the situation. So first, from that moment, from the point of appointment of judicial officers, because it is now common knowledge that the appointment of judicial officers these days is influenced primarily by politicians. It's also influenced by senior members of the judiciary who bring in their spouses, their children, and all whatnot. Now, it makes it difficult first for people to even have confidence in these people that are being appointed. And from then on, you now also have the disciplinary issues. A lot of them are unattended to, a lot of them are thrown out for very flimsy reasons. And when you have a situation like that, then there's no accountability. And when there's no accountability, of course, anyhowness will reign supreme. So, with that, of course, if we are able to correct a lot of these things by the NJC, then of course we're going to be making some progress. The Legal Practitioners Disciplinary Committee itself is a committee of the body of benchers, which is essentially meant for the discipline of lawyers. I have already cited examples where the body of benchers itself, you see, the legal profession is fast becoming more like a cult, where everybody seem to want to protect the other, and at the end of the day, what you have is not palatable for any of us. So when one of us does wrong and we try to cover him up or we try to protect him, and in so doing, this we reduce or diminish public confidence in the system. We do not know, we do not realize that what we are doing is worse than if we had sacrificed that one person who had engaged in unethical practice. But of course, the body of benchers, like I have said, must start from its own desk too, by telling itself that it must do its job irrespective of whose ox is God. Because what we have right now is that we have a lot of big fishes in the legal professions who are untouchable, no matter what they have done or they are alleged to have done. They are untouchable. That cannot be the position. Now, you also talked about the allegations. Well, I won't even say it's an allegation because it was a confession, really, on live TV by a sitting senator that his wife, who is a judge, has been very has been very helpful in, giving decisions in favor of his friends. Unfortunately, you know how that ended. Nothing really happened because he merely came out and said, "Oh, he was misunderstood." This was someone who spoke on live TV, so he was said he was misunderstood, and the wife still sits as a judge. In fact, still sits in very controversial cases till today. Nothing happened. So, do you think other judges who are watching, who are seeing this, and who have realized that, oh, really, this can happen and nothing will actually come out from it, do you think they will be bothered? They will not be bothered. So we're still going to continue in anyhowness. So if we're looking for solution, then instances as this must be thoroughly investigated. Outcomes must be publicized, and people must see that steps have been taken to rectify whatever ills there are. I think essentially that's how to start. That's how to start. And of course, you must also agree with me too that the general decline in morality in our society and generally also affects the legal profession, affects the justice system too. And so while we will be while we'll be implementing targeted steps for the the justice system, we also must also be concerned about essentially bringing society back to, a high moral standard.
Now, you made mention of some persons within the legal system seem to be untouchable. I want to ask, how did we get to that point? There've been the advocacy for independence of the judiciary. Now, if we look at what the attributes of an independent judiciary would be, we can look at the mode of appointing judges, the mode of removal of judges, remuneration, security of the tenure of judges, and other attributes. But let's look at the mode of appointment, the mode of removal, and remuneration. These three attributes, they seem to be very key. So where the mode has empowered the judge or a judge to do as they please and they are untouchable, can we get there? Can we sanitize the system? How do we achieve independence of the judiciary? Would that address the issues of ethical misconduct and the poor reputation that judiciary has right now with the Nigerian populace?
Yes, yeah. Well, there is the issue of the independence of the judiciary, and well, I know that yeah, there are issues to still be resolved, but you will agree with me that uh, as at today, at least at the federal level, the judiciary has gained for itself substantial level of financial autonomy. And before that time, one would have thought, oh, indeed, once we have financial autonomy for the judiciary, oh, it becomes truly independent. But that is not what happened. And we still have, a lot of these issues. The point at the end of the day is that it is not the financial independence that is responsible for the lack of independence. It is not even, it is essentially the fact that there is no accountability, or the mechanism for accountability is not activated when it is necessary. And as such, people continue to do anyhow. When I think it is something that we must just agree. It's common knowledge that when people do wrong and you do not, the system does not punish them, then naturally you're going to see more of it. It is essentially the reason you're going to have uh, high crime rates, where the chances, where people know that, look, if they commit this crime, their chances of being caught and being punished are very slim. They're likely to do more of it. So, as that is the problem with the judiciary. If that changes, trust me, even under the military governments, we had a better judiciary, we had a more independent judiciary, we had more fearless judges. But today, when judges essentially are appointed by, or selected or nominated by politicians, nominated by persons to whom they eventually have to now start paying obeisance. So quite naturally, they must do the bidding of the people who are responsible for for their appointments.
Is good. But I'm still going back to the earlier questions I'm asking. I want to find out from you, are there specific incidences of these unethical practices that are blatant that we can point to? You also have argued that before now we don't have judiciary is bastardized. I also grew up as a little boy to understand that there were some certain court system in Nigeria, secret court system, that if you want to win a case, you have to belong to them. And then, of course, you can be sure of victory at all levels. And I can remember the popular, I told Oga not to do so, somewhere in Benin City some years back. And all these are issues that were quite blatant in terms of the influences that were going on in the judiciary. Don't you think that the value system of our people is very critical, that no matter what selection process you are going to adopt, or whoever you choose, that whoever who is not chosen will still find that these things are not good enough as they should be, since it's not the person occupying that seat?
Well, you see, again, I thank you again for taking us back, and my response will still be in the same line. You see, the issue is not even the capacity, because really, one is not saying, I am not saying at this point now that, oh, judges that are appointed are not fit or are not capable of holding the office. That is not even what I'm saying now. But I am saying that as long as people do not see the system as transparent enough, as long as people cannot say, oh, unlike in the civil service, you can say with reasonable certainty how a person will grow along the line, unless they have specific disciplinary issues. You know that after this number of years, you are entitled to promotion, and even if it is delayed, tops 1 year, this will happen unless you fail this exam, unless you do that. So you can say exactly how somebody is going to grow through the ranks. What we're saying is that with the judicial system, it is not there. That thing is not there. That system that helps you determine who goes where, when, and how. It's not there. There are written rules, but those rules are not adhered to by the NJC. They're not adhered to. The judicial service commissions of the states do not adhere to them, and the NJC, who is supposed to like supervise the JSCs, does not adhere to, does not do anything to make them. So basically, anybody that the chief judge of a state wants gets appointed as a judge. It's as simple as that. But that's not what is in the books, and that's not what it should be. So as long as you have that kind of system where one man can sit down and say, hey, I like your face, become a judge. No, I don't like your face, don't be a judge. Then you are not going to be able to get that public confidence. Remember, quite understandably, there will be instances where there will be disagreement. That one is natural. You're going to have it. It has been there. It will be there. Even in other climes, you're going to have them. But like you said, are these things that rampant? Were they this rampant, for instance, 40 years ago, 30 years ago, for you to hear judges mingling with politicians? And no, it wasn't. They were not, you would not, I mean, you could have one or two instances here and there, but not something rampant. But today, it is rampant. It is what you have all over the place. Now, today, where you have, if you have a judge, for instance, a chief judge, you can be sure that his sons, his daughters, his in-laws are all already placed somewhere, either as magistrates, high court judges, or federal high court, somewhere. They're already positioned to take over from the man when he lives there. Politicians ensure that their wives, their children are positioned in the judiciary such that at the end of the day, as they rise, they become, they become sources of, well, I don't know. They are able to help them get things that they want for. So at the end of the day, this system, and it is now immaterial what actually transpires in each case. It is immaterial that the person really did justice as it ought to be. What is important here is the perception, and I think that is what we're talking about here. Because the ethical standards at the end of the day is all about perception. It's all about perception. What a lawyer, for instance, does in his private space, what he does in his own room, I mean, you wouldn't know. But when he comes out as a lawyer, what he does is what you perceive. What the judicial officer does in his private times, you don't know. But what he does as a judicial officer is what you see. And that is where your perception comes from. So we must be concerned about the perception because ultimately that is what will influence how people will take and receive judgments and decisions from these courts.
Let me just ask this one again, looking at the distinction between morality and law. I heard a senior lawyer once argue that many lawyers make very wrong prayers and then they'll be waiting for justice and say it's clear and evident to all, but in the papers that is presented before the judge, the facts are not there. And then, of course, the judges are supposed to be making their decisions based on what you have presented before them. And of course, you go out to tell people, oh, everybody saw it. But that was not the case as before the judge. And some of all these things are the things that are creating the kind of wrong impressions in the minds of the public, that the judges are very corrupt. And secondly, we also have situations around where you also find that people approach the court, and of course they need to defend their cases before a particular judge, and then they say, oh, I don't want this judge because I feel he has a link, and because I can't trust this person, not really because you have the character defect, but because you're just perceiving that this person is not somebody that you want to do. And these kind of frivolities that comes from the lawyers. So what advice do you really have for the lawyers who seems to be the real link bridge between the judge and the society?
I quite agree with you. There are quite a lot of instances where lawyers do not do their jobs properly, and then when the outcomes do not favor them, they blame the judges. No doubt about that. That's certain. I mean, there is a major political case. I don't know if I would want to, but where the Supreme Court declared a person who contested an election and was not announced as winner, and the Supreme Court declared the person as the winner, and the entire country blames the judges and all of that. But from my little understanding of what transpired in that case, the blame is on the lawyers for the supposed winner, because they did not do their job. They did not present the appropriate documents. They were waiting for INEC to do it, and INEC was disinterested, and INEC did not present the appropriate thing. So they lost, and everybody blames the court. Of course, no doubt, though you have cases like that. But I am saying that is not always the case. And more so, why would it be easy for the society to quickly say, oh, the judges have been corrupt? Perception. Perception. So now back to the uh, the lawyers who do not do their job well. Part of ethical practices, part of ethical standards, which we are still talking about here, is that lawyers must also refrain from publicly criticizing the judges or judiciary. They must, unless there are very compelling reasons for to do so. But you see, part of the decline in ethical standards that we're talking about is that today lawyers grant interviews and openly accuse without any solid evidence. They publicly accuse, and so naturally the laymen, their clients, and the society watching will now toe along that same line, agreeing with the lawyer that yes, indeed there has been compromise on the part of the judges. So, yes, so when we're talking about the ethical standards that must be improved, that also means that lawyers themselves must also be disciplined. So, when you have erring lawyers who go out there, because traditionally the judiciary does not even respond to criticisms. Judges are not usually allowed to come out and respond to criticisms. So, part of the training we had was you don't go out to beat someone who you know cannot cry. I mean, he's not allowed to cry. So basically, that's the point that is being made. So we don't go out there and just basically criticize, call out a judge and criticize them and accuse them of taking bribes and all of that. When we know that they may not be able to come out and respond, that would be an unfair thing. Now, but back to uh, persons, who would argue that they want judges to recuse themselves. The truth of the matter is, as long as a person can give reasons to say that the judge has some links, even if it is remote, with one of the parties or with the case or the subject matter of the case, then it is a good reason, it is a good basis to ask the judge to recuse himself. And like I have repeated here, it is immaterial that the judge intends to do justice, fair justice. It is immaterial. What is important is the perception that justice is not just done, but it is manifestly and undoubtedly seen to have been done.
Thank you very much. Now, before I let you go, I would like you to respond to this question in very few minutes, like a minute or two will be fine. There's this argument that even though legislative activities and duties and law making and enactment in the country is saddled on the shoulders of the legislators, it seems as if the judiciary have hijacked it. And I do believe to an extent that the judiciary make laws through precedents. The Nigerian political space, there is vast criticism coming from politicians that the lawyers are who determines who win elections, irrespective of what transpired at the polling booths. To this extent, we've seen that the social engineering of our system now rests squarely on the shoulders of the judges and the judicial system. Now, from these perception issues, it looks like the judiciary itself is the one or the institution that has taken the nation captive because of the outcry and perception that our elections do not go the right direction. How can we, demystify this perception and to put it in right perspective?
Well, again, I had said it earlier that there must be serious scrutiny uh, of the legal profession, because you see, the politicians will not go to court and file election petitions themselves. They will not file appeals themselves. It is the lawyers that will advise them to do so. And it is when they advise them that they will now brief them and And so again, it still boils down to what we have been talking about, part of unethical practices. So sometimes, first, for us as lawyers, when you find indeed that there is no, there is no, uh, there is no basis for maybe filing a petition or an appeal, you should advise your clients appropriately, irrespective of the temptation of the uh, monetary compensation that will come with it. But that's not the case these days. So it appears like lawyers would always encourage for the politicians to go ahead and file and appeal and do this. And of course, they get paid for all of this. So it appears like, yes, there is need to scrutinize lawyers in that area. And then again, what we have also been talking about still comes into play, because so sometimes you would find some decisions that you it's not supported by logic, it's not supported by law, it's not even supported by facts, and you'll be wondering, how did we how was this decision reached? It boils down to the issues that we've addressed since as well. The fact that there is a failing ethical standard, there is a failing ethical composition within that system. Lawyers will be the ones to actually approach the judges to compromise them sometimes. And so, uh, if we identify all of these problems and see them as real challenges, because you now have election petitions take practically like 80% of the time of the courts within those periods, such that even other cases, including criminal cases, sometimes are not given the kind of attention they are supposed to have. You have a lot of cases of corruption that are pending. They are not attended to because you have election petitions and appeals from election petitions flying all over the place that are time bound, that they must be reach a decision before a particular time. And I think if the appropriate bodies, the body of bencher, the NJC, starts scrutinizing some of these things and probably starts penalizing some of the lawyers who encourage these things, and probably even start looking at the decisions too. I mean, the NJC can review decisions of the courts, and if they find that indeed it is shallow, hollow, and lacking in substance, of course, they should be able to punish those kind of judges, irrespective of whether, yes, there is evidence of compromise or not.
Thank you so much, Deji Ajare, lawyer and executive director, Sterling Law Center, for joining us this morning to talk about rebuilding trust in Nigeria's justice system. Thank you so much for your contribution to the program.
Thank you for having me.
Very much welcome.